everyone. Welcome. Good afternoon. Welcome to the State of Elder Abuse and Exploitation Law in Florida in 2024. I'm Teresa Phillips. I'm an attorney. I work with Forster Bowman. I'm a litigator with mostly having an emphasis on fiduciary litigation over the years, elderly abuse and exploitation cases, and especially in a financial sense, has become more and more prevalent. And I've seen an uptick in my own caseload that involves these types of issues. So this topic has been close to my heart for a while now. This seminar is intended to sort of give us a snapshot of where we are today in elder abuse and exploitation law here in Florida. What are the big issues? What are the recent changes to the law? What's the trend? What are the purposes? What is the state of Florida trying to do in regards to this issue? And then to look at some of the current event stories and see how this is becoming more of a headline issue here in our state of Florida. Well, let's go. We're going to start off going through our agenda on the topics we're going to go over, and then we'll delve right in. Please, if you have any questions, please indicate so at the end of the seminar so we can try to answer those during our time together here today. So we've sort of broken this up into 5 different sections. The first, I'm going to just do an introduction of elderly abuse and exploitation and what it is exactly, and how you can define it and identify it. If you may know, we have presented a lot of seminars over the years delving into elderly exploitation. Today will just be kind of an overview of what it is. Especially as it relates to the financial realm, and give you some background on that and some statistics that you may find interesting. Number 2, then we're going to look at specific laws, and specifically laws that have recently changed or are about to change, and explore why those are changing. Number 3, we're going to go over detecting, reporting, and preventing abuse and exploitation. I suspect I have some fellow professionals here, including and then members of the public on today watching this. So I've designed this to give both fellow attorneys, accountants, and other professionals some signs to look for, and go over our roles in detecting, reporting, and preventing abuse and exploitation. But there's certainly items that any member of the public could probably use in their everyday life to try to protect people that they come in contact with. And then the 4th section is going to be the real life scenarios. And yes, we are going to talk about the Regina Hill matter, which is really in the headlines today here in the Orlando, Florida area, and but it's not the only one. And sadly, there's more stories than there should be about this. But we're going to review those because I think doing that is important to educate ourselves, and you'll see some patterns develop really quick, and start to realize that these cases always seem to have some very core things going on. Finally, as always, we'll conclude with wrapping up with what we went over, where we think the trends are going, and welcome all your questions. Just a few fun facts to kind of set us up today. May happens to be National Elder Law and Older Americans Month. So this seems like a good time to revisit this topic and see where we are. I personally have watched in my 20-something year career, I've seen elder law, especially in the realm of exploitation and abuse, become much more of a hot topic and issue both for lawmakers, law enforcement, and then, of course, as officers of the court and people involved in the legal field, as attorneys. It certainly has touched our own practices, I think, across the board in ways that maybe it didn't 20 years ago. So I think it's great that it has a month now that brings attention to it, and it gives us an opportunity to educate others and share information. So I was happy to see this rather recent designation of May as Elder Law and Older Americans Month. And we have an aging population. If that shouldn't be a surprise to anyone, but here's what I thought was a really eye-opening statistic. Did you know the U.S. Census Bureau predicts by 2050 there will be 90 million Americans in this country aged 62 or older. Currently, it's just under 60 million. That's quite the increase in a relatively short amount of time. So that should kind of give you a snapshot of even though we certainly have an aging population, it's going to exponentially become more aging in the next 20 to 30 years. Let's start with our overview of elder abuse and exploitation. What is abuse versus exploitation? Well, they have some overlap. The abuse of the elderly comes in many forms. It can be neglect, physical or emotional abuse, confinement, intimidation, and then one of the more common ones that we see, at least in the headlines, is the financial exploitation. Um, elderly exploitation has got its own definition, but with regards to the financial exploitation part of it, it's defined in Section 825.103 of the Florida statutes. But you can boil it down to this: it's stealing or misusing of an elderly person's financial funds, assets, income. It's also abusing a trust that you may have been entrusted with, that may be in the shape of a professional, such as a financial advisor. It could be a caregiver. It could be a family member who's, paying the bills, things like that. The law, when you're dealing with an elderly person, the law imposes on anyone who has a position of trust a duty to treat that person even-handedly. Even if they want to make gifts, even if they say it's okay, I want to transfer all my assets to you, you have an obligation to not take advantage of that. We've looked at this before. I won't go into in detail too much, but the basis of this is studies that have shown as people get older, they become more vulnerable and more open to suggestion. And this, we're not talking about dementia necessarily. They don't have to be legally incapacitated. They're just more subject to go along with things that are suggested to them, because that's a natural part of aging. And it's a natural part of becoming more dependent upon the people that are around you. And the law now recognizes that and says it's not okay to just go along and talk someone into doing something that they may agree to. So that's usually when we're talking about elderly exploitation. You've either misused money to your own advantage or to the disadvantage of the person that you're exploiting, and or you've abused a position of trust. And note that even though we're focusing on elderly exploitation, these same rules apply to any vulnerable adult. Being elderly is part of that definition, but it's any person, any adult person that's their ability to take care of their daily normal activities is impaired by some kind of disability, either in the form of physical, mental, sensory, or because of aging. So just note that it doesn't have to just necessarily be someone 60 or older. It can be someone who is disabled and for whatever reason, and they're in a vulnerable state. So approximately 1 in 10 Americans of the age 60 or older have experienced some form of elder abuse. That's a pretty scary statistic. I mean, again, it's not necessarily, it doesn't have to be financial exploitation. It could be a matter of not being allowed outside, being physically or emotionally abused, being scared, intimidated. Elderly can be like, our other vulnerable people in our society, children, animals. If the wrong people can certainly take advantage of that, but I still think that's pretty startling, 1 in 10. Common signs of financial exploitation. All of a sudden, bills aren't being paid. Sudden and unexplained changes in spending habits. If you are familiar, most elderly people have, by the time they reach that sort of age of 60 or above, they have pretty common spending habits that typically don't change. That's not usually a time in their life where all of a sudden they feel like changing their spending habits. It's actually, if anything, they become more conservative. So if there's a sudden change in that, that's usually a sign to look a little deeper. Sudden changes in estate plans, their POA, their power of attorney, or other financial authorizations. All of a sudden, the children have always been their heirs, they're their attorney in fact, they're the person you contact, or the secondary on their financial accounts, and then all of a sudden it's my neighbor or my caregiver. Without some further explanation or reason why that would be the case, that can be a red flag. Retitling of property. Now, I want to be careful. As lawyers and advisors, we sometimes retitle property as part of estate planning or tax planning. But retitling and adding someone without any other reason, gifting essentially, with no estate tax purpose or other planning purpose, that certainly can be a red flag. Forged documents. This can be hard to catch sometimes because as people age, and if any of us, if you have elderly clients like I do, you'll see it. I've had clients that I've been with them for, working with them for 20 years or more, and you'll see their signature change over time. That's natural. The control in our hands and the synapses in our brain will change our signature over time. So just because something looks a little different, it doesn't necessarily mean it means the person did not sign it. So sometimes it can be hard. Is this just, a different signature, or is this someone who's taking advantage and forging the document? So if you see a signature on something that looks a little off, probably a good idea to ask questions and find out if they really signed it. If you see or observe unusual levels of anxiety, fear, and or depression. I've seen reports where medical professionals talk about this, and that sometimes they're the ones that, are essentially the whistleblowers on exploitation, because they notice an unusual amount of looking outside the door, or, anxiety, fear, not wanting to upset someone, and are just very sad. And there's no other explanation. There may be someone in that person's life that's taking advantage of them, abusing them, exploiting them, and it should warrant a little bit more investigation if you see that. If all of a sudden there's isolation and lack of contact with loved ones, that's one of the most, to me, is almost a hallmark of when someone's exploiting someone. When they have a victim under their grasp, what I see is the first thing they do is all of a sudden they have control of that person's phone, who they speak to, they answer the door, they handle the mail, and that's done on purpose. Obviously, they want to isolate them. The isolation makes them more dependent on the person that's victimizing them, and it keeps other people from, hopefully, from their standpoint of the person who's doing the abuse. It hopefully keeps other people from recognizing what's going on, discovering what's going on, and reporting it. If all of a sudden your loved one or an elderly person never wants visitors, never wants to speak on the phone, it's not returning messages, and there's someone always speaking for them, again, that's a sign that you should look at and investigate further. So, why do we even have elder law, abuse statutes and all these regulations? What's the policy behind of it? Why do we as a society care, so to speak? Well, it's what I mentioned before. We're speaking about a very vulnerable portion of our society. And the one thing with elderly folks, as anyone would know that deals with them a lot, there's not a one fits all kind of shape. It's natural to have some memory loss, some mental infirmity as you age, but no one does it at the same rate of speed. People are always in different. You can't say someone's a certain age, so therefore they're infirm this much. It's an 80-year-old and a 96-year-old are not always the same. So you can't always pinpoint just how vulnerable they are, so to speak. Their vulnerabilities also, not just from their age, can come from their circumstances. As people get older, their children get older, um, their children have their own families. It's more common this day and time for adult children not to even live in the same city or state as their adult parents. So they have family that's farther away. Their friends are aging themselves, and may not be able as social, and so they are starting to lose some of those social fabrics that give us all a certain level of structure and strength. So it's not just the age, but the circumstances that lead to this section of our population being more vulnerable. So not from that standpoint, I think there's essentially a moral obligation for all of us to look out for the more vulnerable portion of our society. But there's also a financial cost to it, not just to the people that get exploited, but to us as taxpayers and the state itself. Financial exploitation causes large economic losses, not just for the elderly victim, but for businesses, families of the victims, government programs. It increases reliance on federal health care programs such as Medicaid. Just to give you some common examples, someone's exploited, their caregiver exploits them, and disappears, and you can't recover the money. And then that person who at one point could hire caregivers and stay in their home and had their long-term care planned out is now having to apply for Medicaid for long-term care. Businesses, sometimes when someone defrauds the bank, forges documents, and then disappears, the banks aren't repaid. And then of course, that gets passed on to consumers. The families of the victims, then they have to bear these costs. Sometimes they have to bear costs that normally their parent would have borne had they not been exploited. And so it's not just the one person being victimized. Our whole branches of our society get victimized. Elder populations are particularly vulnerable to abuse and exploitation due to the risk factors that we just talked about. Their aging, physical and mental infirmities, social isolation. Then we've talked about the common include neglect, physical abuse, psychological abuse, financial abuse. But I want to touch on the psychological a little bit. When someone is unable to take care of all their normal activities, when they're truly dependent on someone else to get their food, to help them dress, to help them with their medications, to help them to get to the doctor, there becomes a dependence on that, and there becomes a natural need to not want to upset that person. And keep that in mind when we're talking about going through, well, how do these people end up being exploited and things like that. Remember, they're dependent on whomever, usually in a lot of these cases, of whomever is exploiting them. They have a great dependence on them. They have a great level of trust in them. And so remember that that's leading to a lot of this. Up to 5 million older Americans are abused every year, and the annual loss by victims of financial abuse is estimated to be at least $36.5 billion. So if that gives you some idea why it's not just the one person that's being victimized, it affects all of us. I think that statistic pretty much sums that up. That's a lot. And just on that touch about the financial, I know from experience, recovering the losses is extremely difficult. And getting 100% back is a rarity. But elderly abuse also increases the risk of death. I'm not sure if that's as commonly known as it probably should be. A 2020 Florida law, section 415.1103 Florida statutes, it specifically provided authority for the Florida State Attorney to initiate an elder abuse fatality review team to review deaths of elderly persons caused or related to abuse or neglect in their judicial circuit. They did this so they can be referred to and reviewed, and so that policy changes can be implemented to address the gaps and the problems discovered. Orange County has one of these, and think about that. If this elderly abuse is causing deaths, premature deaths, things like that, I mean, what more interest could, how could something have more of a stake in it for us as a society? And it doesn't, you can not just physical abuse, but taking advantage of somebody, leaving them financially destitute. humiliating them, making them feel even more vulnerable, give mental declines, which can lead to physical declines. I haven't seen any statistics come out yet since the 2020 law went in, nothing that's really significant. Obviously, it's not been that long. But I will keep looking on that, and because I think that may yield some really surprising results. And and I think that would be something important to share with you folks, if I can, if and when we get those kind of numbers. My section D, this is Florida resources. Luckily, we live in a state that has some pretty good resources for the elderly in this regard. Probably Florida and Arizona are the two states in the forefront on this. Not surprisingly, the two states with probably the highest elderly populations in our country. The Florida's Attorney General, their website has some really good information. They regularly update on scams, what are popular scams, ones that are being targeted to elderly persons. They have a senior protection team, and they actually help recover funds. And they've been doing this, I think, for a few years now. They just posted recently that since 2019, they've recovered 7.7 million in funds for Florida seniors. I know Seniors versus Crimes, that's one of the programs they have, which is a great program for recovery, but they do a couple other things. They also do some education. They go to elderly communities, retirement communities, share information on, avoiding exploitation, avoiding scams. They also have a volunteer program, and they actually welcome senior volunteers who they can help with gathering information on scams. What are the latest calls being made out there. They do some mediations, and I think they help with some of the restitution efforts as well. So if anybody's looking to volunteer, if anybody's looking for some volunteer hours and things like that, this is a great little program. I don't think it has as much publicity as it probably should, given our significant population here in the state of Florida, but I welcome you to contact them. I actually have a phone number for them. It's 1-800-203-3099. Let's look at some more statistics. Florida has the second highest percentage of senior residents in the nation. That's not surprising. In 2022, Florida had an estimated 4.7 million people aged 65 and older. That's approximately 21% of the state's population in 2022. By 2030, this number is projected to increase to 5.9 million, meaning the elderly will make up approximately 1/4 of the state's population. And they account for most of the state's growth. With Florida's significant elderly population only expecting to grow over the next 10 years, you can see why Florida is one of the leading states in adopting policies aimed at rooting out elder abuse. And we're going to start getting into those in the next section. But you can see why maybe it's an important issue here with higher priority than maybe in some other states. Like I said, in my experience in research, Florida and Arizona tend to lead the nation on these kind of things. Before I go on to the next section, I just want to talk real quickly because it impacts us as professionals. Fiduciaries and elder abuse and exploitation in Florida. One of the most recent changes I've seen in Florida law is the shift to putting legal duties and liabilities on professionals and those in any sort of fiduciary relationship with vulnerable adults, including the elderly. This means lawyers, accountants, financial advisors, bankers, mediators, and many more that you can kind of think of in those kind of groups. They work with elderly persons on a regular basis. I think there's going to be one day where there may be specific laws that put more of an obligation and a risk of liability on professionals in Florida. I think that's the trend that we're getting to, and we'll talk a little bit more about that in this next section. But I put this as a warning in our introduction because I think one day there's going to be, if we're dealing with elderly persons or other vulnerable adults, we don't want to find ourselves in a position where we are asking ourselves, why didn't we do more? So part of this seminar today is to educate you on that and help you get on ahead of that trend. So with that, let's move on to looking at the actual relative laws on elder abuse and exploitation. Most of these laws are found in chapters 415 and 825 of the Florida statutes. Probably one of the bigger, biggest trends these days, and one of the areas of law that we've seen changing in the last couple of years in Florida, being rapidly amended, is mandatory reporting. But we're going to look into what mandatory reporting of elderly exploitation and abuse is, who's covered under the statute, and what can happen if you report or if you don't report. And we'll also go through, you'll see there was a recent change in this statute, adding more categories, and I think you're going to see that just continue. So section 415.1034 Florida statutes is the mandatory reporting of abuse, neglect, or exploitation of vulnerable adults, and the mandatory reporting of deaths. So it's for anyone who knows or has reasonable cause to suspect that a vulnerable adult has been abused, neglected, or exploited and fits into one of these 9 categories. So if you have a reason to have any reasonable reason to know or suspect that a vulnerable person has been abused or neglected or exploited, and you're one of these categories we go through, recognize that you do have a legal obligation to report. Physicians, and that whole category is different kinds of physicians and people in the medical career, such as nurses, paramedics, emergency medical technicians, EMTs, hospital personnel engaged in the admissions, examination, care, or treatment of vulnerable adults. That's a pretty wide category. Number 2, health professional or mental health professionals other than those just listed in subparagraph 1. So if you're in any way involved in the health field, you should probably recognize that you're probably falling under the statute. A practitioner who relies solely on spiritual means for healing. Number 4, nursing home staff, assisting living facility staff, adult daycare center staff, social workers, people that work in residential or institutions. That makes sense. That's where you're going to find a lot of elderly and other vulnerable adults. State, county, or municipal criminal justice employee or law enforcement officers. Number 6, employee of the Department of Business and Professional Regulation conducting inspections of public lodging establishments. So if you're if you're investigating a motel and you see something that looks like exploitation or abuse, now they're mandatory reporters. Number 7, Florida Advocacy Council or Disability Rights Florida member or representative of the state long-term ombudsman program. So these are people that are probably going to be dealing with fiduciary duties, with fiduciaries, or people who are applying for disabilities and things like that. They're people who are going to be coming in contact with vulnerable adults. If they see something, now they're supposed to report that. Number 8, this is a relatively new one. Bank, savings and loan, or credit union officer, trustee, or employee. Yes, if you're a teller at a bank and you see an elderly person come in with someone being very overly aggressive, trying to get them to withdraw money or cash a check for them, you are a mandatory reporter and should report that. And this one's probably, I think, the newest one: dealer, investment advisor, or associated person under Chapter 517. These are your brokerage account managers and your investment advisors. However, even though you're entitled, or it's mandated that you report, there's no private civil cause of action under the statutes if a third party fails to report or even do something to detect suspected financial abuse. But there is a criminal penalty. A person who knowingly and willfully fails to report a case of known or suspected abuse, neglect, or exploitation of a vulnerable adult, or who knowingly and willfully prevents another person from doing so, commits a misdemeanor of the 2nd degree. That's section 415.111 Florida statute. But I put here parenthetically, has anyone ever heard of a case of this happening where you're criminally prosecuted for failing to report I've not seen one. My research hasn't recovered one. If anyone ever hears about one, I'd certainly like to hear it, especially here in the state of Florida. But it's great that we have this mandatory statute. But when you get the end, it kind of falls flat when you see there's what is the penalty if you don't do it. Um, in theory, criminal penalties, but I don't know if in reality that's something that people have at the back of their mind could happen if they don't report something. So why would a third party not report? Maybe that's the first question that pops in your mind. Well, section 415.1113, subsection 10 of the Florida statute, it specifically grants immunity from liability to any reporter of abuse as long as that reporter is acting in good faith. Unless you're up to nefarious reasons and falsely reporting abuse or suspected abuse, there certainly is no liability. In fact, I think there's confidentiality associated with making complaints to the elder abuse hotline, and unless and until they show that you didn't act in good faith. So why wouldn't you report, especially in light of that? Is it negligence? Or lack thereof that may be playing into part in the role in these third parties who choose not to report. There's no specific statute permitting recovery from a banking institution under Florida law, for example. We talked about the teller actually, the banking employees have a duty to report, but what happens if they don't? There's nothing that says you can, then sue the bank later after the elderly person continues to be exploited after you fail to report. And that, banks are oftentimes specifically accepted out of abuse statutes for civil liabilities. That was probably, I would say, the common trend, and still the rule of thumb in lots of these cases. However, I think that trend may be changing, and we'll get into that why here in just a moment. There's been a long line of cases concluding that no civil remedy against a party who fails to report elderly exploitation exists, including banks. However, relatively recently, there has been some legal precedent that gives support for recovery in some cases, specifically in a case where a bank failed to report. And under that case, they used a legal theory of negligence, not the mandatory reporting statute and obligation, but just old-fashioned negligence. So let's look at that a little closer. This is the Ginder case, Ginder versus Bank of America. It's a Middle District of Florida case. It basically, well, first let's back up. Before then, in 2013, the Middle District of Florida had reiterated that while a person such as a trustee may have a duty to report, the sole remedy is criminal, and that there's no civil complaint under the statute that mandates reporting. So in Ginder, how did they look at it a little differently? In 2015, that decision came out, and I think it gives some precedent to what one could argue to make certain third parties who may have a duty to the elderly person or the vulnerable adult, a theory under which you could recover civilly for someone's failure to report or take other reasonable steps to prevent. In this case, we have an 81-year-old woman who held her life savings of about $175,000 in various accounts at Bank of America. In 2013, an individual falsely identifying themselves as a Bank of America employee convinced this woman to transfer all of her money to other parties. During the few months it took for substantially all of her money to be diverted, Bank of America posted multiple suspicious activity reports on her account. They even got a call from her daughter that they should be on the lookout for fraudulent activity. But despite this, the Bank of America did nothing to stop the transfers, and they made no reports to the authorities or DCF, the Department of Children and Families. So the exploited person sued on 3 different theories and 3 different counts. The first was common law negligence. Then she sued under a breach of Chapter 825 and a Chapter 415. Well, the Middle District on a motion to dismiss or summary judgment early on, they recognized there was no abuse themselves by the bank. So that lost under 825. 415, chapter 415 was the mandatory reporting. That was also dismissed because there's no civil remedy under that statute. But the court did not dismiss the common law count. It held up past initial review. And its reasoning that the court gave in that opinion, I think, kind of gives a roadmap to what others can argue later on. And the reasoning was explained as follows. To state a claim for negligence, a plaintiff must allege that the defendant owed a duty of reasonable care to the plaintiff, the defendant breached that duty, and the plaintiff suffered damages as a result. The duty element negligence is always the threshold legal question, right? If no duty ever exists, then there's no action for negligence. Generally, there is no common law duty to prevent the misconduct of third parties. Typically it's not our obligation to go stop other people from committing a crime. However, a legal duty may arise from legislation, case law, or the general facts of a case. Florida courts do allow and have allowed a showing of a statutory violation to establish the existence of a duty. And that's what the court reasoned on this. Because you have the statutory duty that indicates that under these facts, you may have a duty under common law to report and or take reasonable steps to prevent. So the court said, even if the court was not to look at the act in answering the question of duty, the court finds that the general facts of the case warrant the reasonable inference that the Bank of America breached a duty of care to plaintiff. A duty may arise whenever a person recognizes that his conduct involves a risk of harm to another. The ability of the actor to recognize that his conduct creates a risk of harm is judged accordingly to the reasonableness standard. And if the actor exhibits superior attention, perception, memory, knowledge, intelligence, and judgment, then his ability as a judge according to those superior abilities. So in this case, they analyzed the bank actually was in a very good position to determine that this person was being taken advantage of. As we know, banks, credit cards, companies, things like that, they have programs now that are very astute at detecting unusual activity and flagging things for potential fraud, certainly for unusual conduct. So, and that's what the court noted here. Bank of America undertook the task of discovering the fraudulent activity perpetrated against this person, but they failed to notify anyone. They failed to take any action whatsoever to protect them. The court further said it's reasonable to infer that Bank of America, acting as the plaintiff's financial institution, had superior intention, perception, knowledge, etc., and recognizing there was a risk, and they should have notified someone. And they failed to do so. So accordingly, the court was able to reasonably infer under the circumstances of this case that Bank of America created in itself a duty of care to plaintiff upon learning her exploitation and breached that duty by failing to notify the plaintiff or its investigators and by failing to act further to prevent fraud. So I hope you can see from that that reasoning, you can see where other professionals may come into play who have superior perception, knowledge, and an ability to detect that there might be something going on. So since that case, I haven't seen it. I haven't seen any reported cases here in Florida that have found liability based on negligence in these kind of facts. But I think it's certainly out there, and it's just waiting for the right case and will be tested through our court system. So those working at a bank and other professionals dealing with the elderly and other vulnerable adults, think about that when you're trying to make a decision on whether you should report or not. The Florida Vulnerable Investor Act is going to be the next section. This is probably the newest trend in our laws here in Florida, where Florida's legislature in just the last few years and recently amended our statute so that financial advisors and banking institutions can actually stop transactions and gave them some power that goes beyond reporting. And as stated here, this is what the purpose was. In enacting this law, the Florida legislature recognizes the freedom of specified adults to manage their assets, make investment choices, and spend their funds, and absent a reasonable absent reasonable relief of financial absent reasonable relief of financial exploitation, and that such rights may not be unreasonably infringed. The new law was designed to encourage security dealers, investment advisors, and associated persons to take actions to protect specified adults based upon a reasonable belief that a specified adult with an investment account has been, will be, or is the subject of financial exploitation. So, while they recognize that people should, have the freedom to make their decisions free of government interference, or they do recognize that when someone has a reasonable belief that manages the account or provides investment advice, that this person's under financial exploitation, there should be some ability to restrict things. Of important note, the new law provides that a dealer or investment advisor may delay a disbursement or transaction of funds or securities from the account of the specified adult, or an account for which a specified adult is the beneficiary if all the following criteria apply. The first is the dealer or investment advisor reasonably believes financial exploitation of the specified adult has occurred, is occurring, has been attempted, or will be attempted in connection with this disbursement of the transaction at issue. Number two, no later than 3 days after the date on which the delay is placed, the dealer or investment advisor notifies in writing all parties authorized to transact business for that account and any trusted contact on the account, with the exception of any party the dealer or investment advisor reasonably believes has engaged in, is engaging in, has attempted to engage in, or will attempt to engage in suspected exploitation of the specified adult, of the hold placed on the transaction and reason for the delay. So first, you have to have a reasonable belief that there's exploitation going on or about to go on. Then within 3 business days, you have to let the person know in writing, and anybody associated with that account as well. You have to let them know of the hold and the reason for the delay. The next criteria that must be met is no later than 3 business days after the date on which the delay was first placed. The dealer or investment advisor has to notify the Florida Office of Financial Regulation of the delay, and that's done electronically, and they actually have a form that's been prescribed by rule. And then finally, the dealer or investment advisor immediately initiates an internal review of the facts and circumstances that caused the dealer or investment advisor to reasonably believe the financial exploitation of the specified adult has occurred, is occurring, or is about to be attempted. So again, you can delay, but you have to have a reasonable belief. You have to report to the person and the people associated with the account within 3 business days. You have to report to the Florida Office of Financial Regulation within 3 business days. And then finally, you have to do an internal investigation. So how long, let's say, you have a client that you believe is being financially exploited. They wanted to do a, $100,000 withdrawal. You've met all the criteria, you issue the delay. How long does the delay last? The delay on a disbursement or transaction under the statute expires 15 business days after the date on which the delay was first placed. However, there's an opportunity to extend that for 10 additional days if the dealer or investment advisor's reviews of the available facts and circumstances continue to support such dealer or investment advisor's reasonable belief about financial exploitation. A dealer or investment advisor that extends the delay must notify the Florida Office of Financial Regulation on that form prescribed by rule no later than 3 business days after the extension is applied. Note, any delay can be rescinded by court order or by the dealer investment advisor if any further communications with the account contact person or other communications after that, they no longer feel the delay is warranted. So even though you can delay, you can go back and rescind the delay or end the delay if circumstances change, or if someone goes and gets a court order that lifts the delay. Other than what we just talked about, the Florida Office of Financial Regulation, is there a requirement to share this information with third parties? That's the only requirement under the statute, and obviously you have to reasonably comply with requests, because the Office of Financial Regulation will probably open an investigation. But you don't have to share with other third parties, and depending on the nature of your representation agreement and terms with your client, you may be able to, maybe they have a trusted contact person that they authorize you to talk about the account. There could be other people that you should contact, or have to contact, but that just depends on the circumstances of each account. Okay, so are there any other prerequisites for delay can be initiated? Well, before placing a delay on a disbursement or transaction, the dealer or investment advisor must have developed and put in place training policies or programs reasonably designed to educate the associated persons on issues pertaining to financial exploitation. They also conduct this training at least annually, maintain written records and transcripts of all the training conducted, and develop, maintain, and enforce procedures regarding the manner in which suspected financial exploitation cases are reviewed internally, and if applicable, the manner in which they are required to report to supervisory personnel. So here they put a burden on the any institution. Before they initiate a delay, they should already have trained their individuals and have protocols in place, and they have to update this annually. I think this is trying to do is make sure that people aren't doing this loosey-goosey, that they have specific guidelines to go by. They're specifically trained on what to look for and when they should be concerned, and the reporting procedures to make sure they don't run afoul of any of the rules. So what's the liability for acting or not acting in this case? A dealer or investment advisor who in good faith and exercising reasonable care complies with Section 517.34, they're immune from any administrative or civil liability that might otherwise arise if you had delayed someone's disbursement or transactions. Absent reasonable belief, the new law does not really alter any kind of agreement or obligation you have to comply with your client's instructions with a financial account. So normally, you would have a legal obligation, but if you act in good faith and you comply with the statute on the delay, you have your client can't sue you, or there's no liability from any damages that might arise or anything like that because of the delay. We've got an amendment to this coming up. It's effective July 1st, 2024. So again, it's got similar, it names similar policies. It says it does the same thing. It's not creating a new relationship or altering the obligations between the investment advisor and their clients, except for this one circumstance where you have a good faith belief that there is financial exploitation. And the only really the change to the statute, all the beef stays in place that we just went through. All the beef of this statute really stays in place. There's delays. There can be extensions if all you meet the criteria. What it really the real big key difference here is they're putting a obligation on financial institutions to develop certain trainings and policies, not to educate their clientele, which was similar, but they're getting more specific on what that is and on keeping records of that. And they have to create at least maintain records at least 5 years after the date of the delayed disbursement or transaction. So that's the real changes are beefing up exactly what's going to be in the training and how it applies to financial institutions as a whole, and then requiring to maintain records for at least 5 years relating to these delayed transactions. Okay, so we're now in section 3, and this is detecting. How do we detect? What should we be looking for? So let's look who should we be looking for. Who takes advantage of seniors and other vulnerable adults, and why? The abusers can be friends, acquaintances, total strangers, professionals. family, con artists, paid caregivers, anybody who's coming in contact with them. And it certainly can be someone who exploits. It can be the lawn maintenance person who starts up a conversation with a person one day when they notice nobody else is there. It can be total strangers. People, there is a group of folks that target elderly folks, and they find ways to insert themselves in their lives. And we'll go through those as some of the real life scenarios later. According to NAPSA, the following factors contribute to the prevalence of senior financial abuse. A high percentage of seniors live alone, and that makes them more vulnerable to scams. Generally speaking, age 60 is the optimal age for financial decision making, and the ability to make financial decisions starts to decline from that point on. In contrast, the senior's perception of their financial decision-making abilities does not decline. So there's a widening gap there where your ability is actually declining, but you're not perceiving that it's declining. And there you have a perfect opportunity for someone to come in and exploit. Seniors can be very trusting, and they may have trouble spotting fraud. We've looked at this in some other seminars I've done. There's studies that show that with aging, it's natural to become more trusting. Our abilities to be suspicious about the environment behind us, around us, for some reason, diminish as we get older, for the most part. Seniors, on average, have a net worth substantially higher than younger consumers. You know, they've accumulated their retirement, they've accumulated assets, so that makes them more of a target. More seniors live alone than ever before, and I can't reiterate that enough. That living alone and not having other people around you, and not having that structure, can make you very vulnerable to someone who seems like they're filling a gap in your life. The population of seniors is increasing rapidly, providing a tempting target for abusers. You know, they're the fastest growing demographic in this country is single women who are age 85 and older. And that's because, you know, have good health care, we live longer, and, you know, have the financial resources to take care of ourselves longer. So that group, that demographic is actually exploding. And so that makes you a tempting target too. Critical step in helping our older clients is to look at ways to help them avoid abuse in the first place. So here are some tips that I give out to folks who ask me, what can I do? Clients who ask me, family members who ask me, you know, right now everything's okay, but what do I do today that maybe can prevent me from being a victim tomorrow, or, you know, prevent my client from being a victim tomorrow? Consider setting limits on your check amounts and account charges. You can voluntarily do this in most institutions. Set up things where if you can't go over this limit without coming into the bank, or you can't go over this limit without someone being contacted, things like that. And that goes into number 2. You set up notifications to trusted persons for activities that affect your credit, including, you know, not just doing, you know, making withdrawals or putting things on credit cards, but making credit application filings. So not only notifying yourself, but notifying your most trusted family member or an advisor or something like that. It's a good idea. A lot of times the exploitation is simply getting enough of their contact information, their personal information, such as their social security numbers, and going out and making credit applications, which are primarily done online now. We've had cases where there's been a whole loan done and nobody ever realized they weren't dealing with the elderly person at all. So, you know, having something that alerts you if a credit application filing goes on someone's report is a good way to just see that something may be awry. Help build a safety net or team that incorporates, care managers, do a collaborative effort. Depending on the circumstances of the person, the level of the team you need will depend on that. If they have CPAs, they have insurance consultant, trust officers. Everybody should be talking to everybody. If an estate planning attorney all of a sudden gets a request to change a will completely, hopefully you've already, gained permissions from your clients that I can call your banks, your financial advisors, and see if maybe something's gone awry. you can build in safeguards into your own legal documents too, because as you'll see with some of these live case scenarios, we're dealing with people that are, already named in a power of attorney or some other document. So, have co-agents, have co-trustees, um, trust protector, have people that, someone's looking at someone else, at least when it goes beyond the normal activities. You can establish a revocable trust and have a trust protector named, who is not the trustee. This is probably for people that are really getting along in age and, and need to give up and should give up a lot of their control over their finances. That won't be an option for practical reasons for everybody. Maybe I can't emphasize this enough about powers of attorney. You have to make sure the clients understand that a power of attorney is insufficient to protect them from abuse. In fact, it can be used to abuse them. They need to plan a little bit more broadly than just saying, well, I have a power of attorney in place. Believe me, not just the person that's named in the power of attorney, they can be a problem. But if a third person gets a hold of them, believe me, it's easy to revoke a power of attorney. And you'll see that over and over. But I see so many people say, well, I have a power of attorney. My daughter has it. I'm not worried. That's really not sufficient. And having an independent person named it, or at least as a co-person who will be, for certain, at least a certain threshold level of transactions is always a good extra step for a safety net. And make these concrete steps before your client exhibits signs of decreasing cognitive ability. Make it as people lose, their ability to perceive things as they once did. It gets harder to put these things in place. They don't perceive themselves as being vulnerable or in danger. The sooner you talk about these things, the better. The National Council on Aging offers a variety of consumer resources. Elderaffairs.org is a great place to start. I see that we're getting close to our hour, and we haven't got to go through a lot of the fun stuff. So go through the materials and it'll talk to you about preventing and being proactive with elderly clients. I do want to get to the suspended Orlando Commissioner Regina Hill, pleads not guilty ahead of arraignment case. That has been in the headlines. The latest is, if you don't know the facts, Regina Hill was an Orlando City Commissioner. She's been removed by the governor, but she, for about a year, she was investigated when one of her employees reported that she was exploiting one of her constituents, who's 96 years old today. It started out, as a lot of these start out with good intentions. She seemed to be helping the lady, who was living in derelict conditions, and she got some community resources together and helped her out to fix up her house. But shortly thereafter, I think within a month, she had a power of attorney for this lady. And since then, she's purchased homes. She lives in one of the homes. She's used her money to the tune of $100,000 to buy personal effects, such as vacations, such as, luxury hotels, dental work, things like that, cosmetic work. So it's a really sad case. It looks like the lady had no idea. And it's one of these cases where she did a loan in the name of this person who apparently has no idea. These are all the allegations. You can find them in the affidavit of the investigator online. That case is pending. But I think it's really grabbed people's attention because she's looking at up to 180 years in prison. Of the counts against her, 3 of them are for elderly exploitation. They're all felonies, first-degree felonies. So I think, that's good in the sense that people see that this is a real crime. And people should be punished that do this. It shouldn't, and we as a society have to do that because the elderly person oftentimes doesn't even want to bring attention to the fact they've been exploited. I mentioned some other headlines here because this is an unusual case. You can Google these headlines, the financial exploitation of a Florida senior, April 11th, 2024. You're going to see where that was an 82-year-old who was taken advantage of by their power of attorney, named attorney in fact, where he started spending all and paying all his bills from their account, essentially. We got a caretaker associate charged in financial exploitation of a 97-year-old in Miami-Dade. Again, this was just in March of 2023. And this case was sad too because the person, her caregiver, essentially took over her finances and got a POA and started making withdrawals. And luckily, the investment advisor noticed some wayward activity and reported to the family so they could stop it. And now they're charged criminally. So, what's the trend? It looks like the criminal prosecutions are up. It looks like the laws are tightening up to allow us civilly to try to prevent these things from happening. And hopefully those trends will continue to protect our elderly community. Thank you for joining us today.